Hi, I'm Anika Ranchhod, Solicitor at Williamson-Barwick, a specialist employment and industrial law firm. In recent years, there has been a sharp public focus on employers who have underpaid staff or engaged in other unlawful behaviour affecting an employee's pay. The term wage theft has become a media catch-cry. According to the Fair Work Ombudsman's annual report for 2020 and 2021, $148 million was recovered through requests for assistance involving a workplace dispute and Fair Work Ombudsman investigations, including of large corporates self-reporting underpayments. And so, all employers must place a much higher priority on investing in payroll human resources systems and access the necessary expertise to ensure they are paying workers their lawful entitlements. So what exactly is wage theft? Well, while previously coined as an emotive term to describe a wide range of underpayments, it is now considered a criminal offence in both Victoria and Queensland. According to Victoria's Wage Theft Act of 2020, it is a crime for an employer to deliberately and dishonestly underpay employees and withhold wages, superannuation, or other employee entitlements. But the line isn't only drawn there. It's also a criminal offence to falsify employee entitlement records to gain a financial advantage and avoid keeping employee entitlement records to gain a financial advantage. And if you were caught doing this, brace yourself for some serious penalties. Employers in Victoria face a fine of up to $218,088 or up to 10 years jail time. And companies are looking at fines of up to over $1 million. In jurisdictions other than Victoria and Queensland, employers and persons found to be accessories can expect a court to impose significantly higher civil penalties where the conduct in underpaying an employee is deliberate. From our experience, we have identified 3 typical forms of underpayment. The first is deliberate and systematic underpayments. In other words, the entity has gone out of its way to underpay its staff. Examples of this form of wage theft include unauthorised deductions from employee wages, cash payments with no pay slips, sham contracting, tampering with timesheets to create fake records of work hours, and commission-only packages. Then you have genuine unintentional underpayments, caused by a failure to correctly identify the applicable modern award or a misinterpretation of an award and employee entitlement. Incorrectly classifying your employee under the award could also lead to underpayments. Other common causes of unintentional underpayment include inadequate record keeping, mismanaged annualised salary arrangements, and human error. And lastly, we have what we call head in the sand underpayments. This is generally a result of inadequate payroll systems and a lack of HR expertise. However, it could also result from a lack of attempt to identify the applicable modern award and myth-based payments. For example, you decide without research that all salaried staff don't fall under the modern award system and therefore aren't entitled to overtime. Just to give you an example of how laser-focused the Fair Work Ombudsman has become on stopping wage theft and underpayment generally, employers have not only been required to compensate employees and pay significant penalties, but they have also been named and shamed on the Fair Work website. No employer, large or small, is safe. And the Fair Work Ombudsman is not just enforcing the law to protect minimum wage workers. In fact, the Fair Work Ombudsman recently commenced litigation against supermarket giants such as Woolworths Group Limited, Woolworths South Australia Proprietary Limited, and Coles in respect of underpayments of salaried managers. But appropriately, some employers have self-reported to the Ombudsman, including Baptist Care following a review of annual leave for shift workers and associated leave loadings. The organisation had identified that it had incorrectly applied clauses of the relevant enterprise agreements of 2011 and 2014 with respect to entitlements owing to shift workers. Westpac also reported themselves for underpayment of long service leave entitlements. So how can you avoid finding yourself in this position? For starters, you need to ensure that your HR processes are 100% compliant. We recommend that employees consider the following when undertaking a health check on legal compliance. Number 1, ensure the organisation has fully identified its obligations to pay employee entitlements. This includes modern awards, enterprise agreements, the National Employment Standards, and contractual obligations. And if you're unsure at any stage of this process, get help from an expert. Number 2, review whether your payroll staff are equipped with tools and training to understand employee entitlements. Also, managers and supervisors with responsibility for rostering need to be trained on lawful rostering arrangements. Number 3, consider any impact of annualised salary provisions for relevant award employees. With the recent changes to annualised salary provisions, this has caught a lot of employees off guard. Number 4, equip payroll staff to ensure they proactively address any upcoming changes, such as award pay increases. Number 5, either allocate an internal HR or legal specialist who can manage the risks associated with employee entitlements. If you're looking for a legal expert to help guide you through one or all of these suggestions, the Williamson-Barwick team is ready to help. Our firm has advised both employers and employees on some of the most challenging and complex underpayment claims across various industries. We can help you ensure you are compliant with workplace laws. As a result of this experience, we wanted to create a risk management tool to help employers pay in accordance with the law. And so, Paylex was established. Paylex is essentially an expert legal review that helps organisations identify compliance issues within their employment practices. Too often, businesses discover errors only after a legal liability has arisen. And as you have seen, underpayments claims can result in substantial compensation orders, penalties, and legal costs. A Paylex report, which is tailored to your industry sector and unique circumstances, can help get your business on the front foot with employment laws, awards, and enterprise agreements, meaning your organisation can stand out for compliance excellence. Our specialist employment lawyers provide a legal perspective on your employment practices that a human resources consultant can't. Compliance builds trust with your employees, supports staff retention, and improves organisational efficiency. It's also worth noting that our Paylex reports are confidential, and unlike advice from a HR consultancy, it is subject to legal professional privilege. So, if you'd like to find out more, please don't hesitate to reach out to us for assistance.